afternoon, everyone. Thank you so much for joining us this week for our webinar series. Today, we'll be discussing the topic of civil litigation. We'll be walking through exactly what it is in the context of employment or another civil disputes, as well as how to prepare for them. Now, a bit about us. We are Achkar Law. We are one of the fastest growing firms here in Toronto. We were first founded back in 2016, primarily focused on employment law, human rights law, labor law, and civil litigation. We also do workplace investigations and have a growing commercial litigation group. We serve all across Ontario as well as other provinces across the country, with intentions to eventually expand into other parts of the country as well. Today's seminar will be led by myself. My name is Charles Miller. I'm a senior associate here with the firm, and I'm joined by my friend and colleague, Philip Petrovic. He's a partner here at the firm as well. And so to kick us off, what is civil litigation? Well, civil litigation is the legal process of resolving disputes. Anytime typically this will happen if someone initiates a claim against you. So if a claim has been filed with the court, that is when things are kicked off. These types of disputes are between individuals, sometimes between organizations, and sometimes between organizations and individuals. And the entire court process actually has a step-by-step guide once civil litigation has been initiated about what sort of roadmap to walk through when a claim has been initiated in terms of when to file your next document, which form is due, where to go through from there. Civil litigation, just so you're aware, is a bit distinct from criminal law as it deals with disputes between parties rather than offenses against the state. So civil litigation is between people. Offenses are someone's committed an offense and the Crown or the country is bringing a claim against them. There are two main veins when a civil litigation is initiated for us to be mindful of. The first one is a small claims court. This is for any sort of claims under $35,000. These are much more user-friendly type of rules, as about the rules of small claims court govern the small claims court proceeding. Much more user-friendly, a little more informal, and there's less legal steps to go through. There's also the Superior Court of Justice. This is for claims that are over $35,000. These claims are a little more complicated. The Superior Court of Justice is governed by the rules of civil procedure, far more advanced, a lot more rules, a lot more nuance. There's a lot more steps to go through in the Superior Court of Justice for these claims. So it's highly recommended that you have a lawyer walk you through it. And in fact, if you're a corporation, such as an employer, you actually must have a lawyer represent you. Otherwise, your entire defense could be struck. Now, the rules of the Superior Court of Justice also has a Rule 76, which is simplified procedure. Those are for claims that are over $35,000 but under $200,000. And it's just a more streamlined process. It moves a little bit quicker. It's still just as complicated, but it just moves a little bit faster. Whereas claims over $200,000, that amount of money doesn't move quickly ever. And so it's a little bit more involved in that step. So there are many types of civil cases that you might see or that might come across your desk. One of them being contract disputes. These might occur if, say, someone has been hired to renovate your home and they aren't using the type of bricks that you contracted them to utilize. We've now got a breach of the contract between the parties and a claim might erupt. You might see property disputes. These are claims such as an agreement of purchase and sale falls through because somebody didn't get the guaranteed funding that they needed, and so the house sale just fell through. You might also see torts. The word tort is just a fancy way of saying any wrongful act that has occurred, such as damage for nuisance. Let's say if somebody keeps smoking some like marijuana outside your front door, so it's causing a nuisance and causing your place to smell, you might have a tort there. You might see a lot of wrongful acts or torts for motor vehicle accidents as well. Another type is intellectual property disputes. These occur if somebody steals your ideas or runs off with your copyright and tries to produce the same product. You may also see shareholder disputes. This occurs if, say, some member of the company or shareholders diluting the value of the shares due to their actions or due to decisions they're making. You may also see partnership disputes, which may occur if, let's say, you get into business with somebody, everything's going fine and dandy at the start, but then for some reason or other, they start to devalue the company or start to take action that actually harms the value of the company and wrecks it in some way. Breach of confidence claims may also come forward. These occur a lot in the context of an employee revealing company secrets, such as, let's say, a client list, and just sharing it all willy-nilly across public or taking it to a competitor. You may have a breach of confidence claim there, as well as employment litigation. So employment law civil litigation comes in many different flavors. The first one and the most straightforward one is a wrongful dismissal claim. Now, as an employer, you are permitted to terminate your employees. However, when you do so, you need to make sure that you pay their full entitlements. An employee's full entitlements is determined by something like the Employment Standards Act, as well as the common law, and whether or not how much they're owed depends on the circumstances of the case. A wrongful dismissal claim will be initiated if you terminate an employee and they come forward and say, hey, you didn't pay me enough when you let me go. And they're suing you for more reasonable notice. Similar to that is a constructive dismissal claim. This is different from wrongful dismissal in that the employee doesn't get fired, but they're alleging they were forced to quit, saying that due to some breach of the employment agreement or harassment or bullying in the workplace, they could no longer work there anymore, so they were forced to quit. It is the same sort of damages as a wrongful dismissal in terms of reasonable notice, but then you may also see claims for aggravated damages, punitive damages, even some human rights damages, depending on why the employee feels they were forced out of their position. Constructive dismissals are far more complicated and a lot more involved. You may also see in the employment sphere discrimination claims. Now, discrimination claims are guided by the Ontario Human Rights Code or the Canadian Human Rights Commission. And a lot of this comes down to what are these special grounds that an employee should not face any discrimination for. So under the Human Rights Code, you have certain protected grounds under certain protected social circumstances. One of the social circumstances or areas is your employment. So while you're employed, you are not to face any discrimination on grounds such as place of origin, where you were born, color of your skin, your sexual orientation, your religion. If an employee faces any discrimination on those grounds while in the employment sphere, then you as the employer might be liable or might face a claim arising out of discrimination. Another area is workplace harassment and bullying. This is closely tied to discrimination and constructive dismissal claims, in that an employee is going to come forward and say, hey, I was deeply bullied and harassed in the workplace by, say, a manager who was micromanaging me and coming down too hard, or by a colleague who was picking on me every day, and you, the employer, didn't do anything to stop it. You might see a workplace harassment and bullying case. It doesn't necessarily have to be discrimination. But essentially, if you as the employer don't do anything to make sure that you have a harassment-free workplace, you may come across a harassment and bullying claim on your desk. Another type of employment claim you might have is a wage and hour disputes. These are employees coming forward and saying that you didn't pay their wages properly, such as you owe them some overtime that you didn't dock and you're refusing to pay. These might end up being a Ministry of Labor complaint, which can be very complicated as well. Other types of claims are the employee misclassification claims. These tend to emerge when an independent contractor alleges that they were actually an employee the whole time. This can occur. You may have hired someone as an independent contractor to perform a service, but if it turns out that they weren't really treated as an independent contractor, but were actually treated as an employee, such as you dictated the hours they worked, they couldn't hire anybody, they had to use your tools or come at a certain time, you didn't remit the taxes, the payroll taxes, there's a whole test to determine if they were an independent contractor or an employee. And if you terminate an independent contractor agreement and they come forward and say, actually, I was an employee the whole time, the employer might be liable for some loss or some reasonable notice and wages lost there, as well as some penalties for employee misclassification. Another type of dispute is the breach of an employment contract. Uh, this is also tied to constructive dismissal claims. Essentially, an employee comes forward and says, "Hey, I was told I was going to be paid $75,000 a year in remuneration, and you've now brought it down to $60,000. I didn't agree to this." Or you have docked their vacation pay, or you've increased their duties substantially. As an employer, you do have some leeway to introduce new duties to an employee outside the original agreement within a certain reason. But if it goes above and beyond that, you may be looking at being accused of breaching the employment contract. And then another type of employment law civil litigation you might have are leave disputes. Under Ontario law, employees are permitted to have certain protected leave, such as bereavement leave, sick leave. And if for whatever reason those leaves are not respected, or they're infringed upon, or there's some sort of punishment for employees taking that leave, they may bring a claim arising out of that as well. And so Philip has a point to bring to that as well.
Just something about misclassification. I often get asked, well, why is there an issue if the employee agrees to be classified as a contractor? And the law basically says it doesn't matter. If you agree to classify an employee as an independent contractor and they're still benefiting from it, you can't use that against them. And the law will say that, you should have known better. And so you can't avoid that liability just because it's a mutual agreement. So always keep that in mind.
Thank you, Philip. And so, with all these types of claims in mind as an employer, you can probably see that there's a lot of potential liability as an employer. So, what should you do if a claim comes across your desk? Fortunately for you, I'm going to pass the torch over to my friend Philip. He is going to walk you through exactly what you should do if a statement of claim or any sort of litigation comes across your desk.
Thanks, Charlie. So, for those of you that were with us last week when we were talking about responding to human rights claims, my presentation now is going to be a little bit similar in some respects, in that you respond to a civil lawsuit the same way you would to a human rights lawsuit. So, the most important thing, first of all, is to review what you receive and consult a lawyer immediately. And the reason why you want to consult a lawyer immediately is because typically you have 20 days from the date you received the claim to actually respond. Now, just to clarify further, receiving the claim, it doesn't mean that you yourself got it in your hands. Rather, it means the claim was served on someone in your office, for example, and they received it. So if my receptionist receives a claim and she doesn't give it to me in 10 days pass, and then she gives it to me on the 11th day, I still only have 9 days to respond and not the full 20. So always keep that in mind. First thing you do, you review the document, consult a lawyer, give them a copy, because again, you have limited time to respond. And just like when you're responding to a human rights application, you respond to a statement of claim the same way. You gather the evidence, you make your notes, and certainly I can tell you in terms of like for example, our internal intake process, we will always walk through a claim with each client we have and see what is correct that they're alleging, what is incorrect, what is completely frivolous, and so forth, so that we can gain a better understanding of what the claim is against the person we're helping. So very important. Apart from just defending the claim, you may have a counterclaim or a cross-claim. A counterclaim typically comes up when, for example, you get your company is sued, and then you realize, oh, well, I have a claim against this individual, for example. Typical example might be so an employee sues you for dismissal, and you counterclaim for breach of a non-solicitation covenant in an employment contract because this particular employee stole business from you and stole clients from you and stole employees from you and so forth and so forth. So you sort of discover that you actually have something against the employee. A cross-claim is a little bit different than a counterclaim. What a cross-claim is essentially you, when you're sued, when your company is sued, you're essentially claiming that someone else did it. So it wasn't It's, the liability is not mine. It's not my problem. It's actually someone else's problem. And this is who that someone else is. So that's essentially just sort of shifting liability onto another party. So I touched on this a little bit briefly, but
Sorry, Phil, may I just add something to the last point that you raised?
sure, of course.
Perfect. So as Phil was saying about cross claims being typically when there's multiple defendants and you can kind of point the finger and say, yes, this may have occurred, but if it occurred, it's actually this other person's fault. Uh, there's also third party claims where another defendant may not even be listed. And then you bring them into the fold as well and say, same thing. It's not my fault that this occurred, but this other person who hasn't been named, they should be brought in and they're actually liable. Thank you.
Thank you. So in terms of the risks of not responding to a claim, there are a few. One, if you don't respond at all and you just ignore something and you think to yourself, well, if I ignore it, it may just go away. The answer is typically it won't. What a plaintiff can do in that kind of a scenario is they can note you in default. And what that essentially means is you haven't responded according to the court's timelines. Therefore, they're allowed to proceed and push their case forward without your involvement. So to give you sort of a real life view of what that looks like, just imagine someone going to trial, making submissions without anyone there to defend. So it's a one-sided trial. Think of it that way. And the risk of a successful default judgment is the plaintiff will obtain some or all of what they were asking for, what they were seeking. So they may obtain partial damages or they may obtain full damages. At the end of the day, even if a party has defaulted on its obligation to defend, you as the plaintiff, you still have to prove your case. So it doesn't, defaulting on a statement of claim doesn't necessarily mean that you will immediately lose, but it certainly doesn't help if you're not able to defend yourself and at least tell your side of the story. So it's absolutely important to respond. I can't stress that enough. And it's even more important when you think the plaintiff may not even have a case, but you may help them by failing to respond. So always keep that in mind. So you lose your legal right to respond, financial consequences. Apart from getting a award of damages against you, you may also get an award of costs against you. And by that, I mean you may have to pay some or all of the plaintiff's legal fees that they spent in enforcing their judgment and pushing their case forward. So that's something to keep in mind. And the costs can often be quite expensive. And reputational damage. So something a lot of people don't know is that when cases go to trial and they go to court, eventually they get posted online in a database. And that database is available to the public. Now, you won't know if it's there unless you really look for it, but it's not that hard to find, and you can find it even just by Googling. So the website is called CanLii, that's CANLII.org. And a lot of the cases that happen across Canada are posted online. So as an employer, you may, for example, ignore a claim, refuse to respond, and then one day you go online and there you have your company being sued for a default judgment, and you see a successful order against the company online. So something to keep mind about and just think about. It's important, and again, can't stress enough. If you get a claim, respond, deal with it, be proactive. Don't just pretend it's going to disappear. I promise you it will not. On the one hand, you can defend a lawsuit, and that sometimes happens. On the other hand, you may want to commence a lawsuit. The few things that, whenever we're looking at whether a lawsuit should be started at all, there are a few things we consider. And this is something we would discuss with you at length, but basically, is there merit to your case? Is there a point? Is it a frivolous case? Is it a case that has a sense of reality? Is there a chance of success? Are you asking for something that is obtainable, or are you asking for something that is absolutely impossible to obtain? Do you have evidence? And by that, it's good to have verbal evidence, he said, she said, but it's even better to have written evidence. Is your case in time? So typically, for most cases in Ontario, you have 2 years to do something. So that means, for example, if I discover a case right now, what is it today, April 30th? If I discover a case now, I have 2 years until April 30th, 2026 to actually do something about it. Now, there are a million exceptions, so it's not a one-size-fits-all. For example, human rights cases have 1 year. So the best thing to do is if you ever do think to yourself, oh, I have a case, you should immediately speak to a lawyer, figure out what you can do, and whether or not you have any time restrictions and deadlines that you need to be aware of, because it is possible to commence an action on short notice, but it does get a lot trickier as you run out of time. So, um, financial considerations, cost versus benefit. I mean, is it worth it ultimately? If you are suing to recover $1,000 and you think you're going to pay $2,000, that's already a bad business decision. So that's something to think about. Recovery likelihood. I mean, for example, if you sue a company that has no money, or you sue a company that's, for example, bankrupt, legally bankrupt, you have to ask yourself whether, even if you succeed on the claim and whether you prove your points and make your case, will you be able to recover even a dollar at the end of the day? And that's something to think about. It is unfortunately a consideration. And as they say, it's impossible to draw blood from a stone. Alternative dispute resolution, ADR. So anytime you do initiate a lawsuit, there are certain ADR mechanisms that our court provides. For example, mandatory mediation. Now, outside of the civil court system, there are ways to use ADR privately in order to resolve disputes. For example, there's such a thing that's called arbitration. And arbitration is essentially think of it as a trial uh, that's private. So instead of going through civil court and obtaining the services of a judge who's going to hear your case, you instead hire a private arbitrator who hears the case and makes a binding decision on the parties, and it's typically behind closed doors. So there are some benefits there. It is a little more discreet sometimes, and the costs can also be a little more controlled. You kind of know what you're getting into a little bit better, but the result is still the same and the outcome is still the same. If you win, you win. If you lose, you lose. Contractual obligations, business relationships, public relations, personal or corporate philosophy, those points you should always think about, especially if you are thinking of whether to start a lawsuit on behalf of a company. And the reason I say that is because, again, lawsuits become public knowledge. Lawsuits can often get messy and dirty, as they say, and you have to think about what type of an image you may want and potentially what kind of an image you may want to preserve. So, for example, if you are suing an employee and you are maybe suing them for something frivolous, or you are doing something oppressive, if that ever becomes public, it will be public forever. And case in point, Charlie and I, whenever we're conducting research, we'll often check online and see which new cases have come out. And sometimes we'll find cases where employers were actually abusive or did something during litigation that was high-handed, sort of backsided, and it all becomes public. And once we see it, we know all about it. So litigation is not necessarily discreet, although sometimes it is absolutely necessary. So those are some things to think about whenever you're deciding whether you want to go through with a lawsuit. So it's not just about suing someone and winning a case. There are financial and other considerations that exist. So always something to keep in mind. And of course, consult with the lawyer, because it's not easy to navigate a lawsuit, and you may always find new things and new ideas that you didn't know existed before you consulted a lawyer. So absolutely imperative. Folks, you have our contact information here. Feel free to email us. I thank everyone for joining today, and have a great rest of your week.
A wonderful week, everyone.